Well, good morning, good afternoon, good evening. Welcome to Chapter 13 here at the Wake Tech course, Court Procedure and Evidence. This course is being taught in the spring of 2023. We are using Joel Chimera's textbook published by Cengage called Criminal Procedure. This is the 10th edition that we're using. And as I said, or as you probably can see from the slide here if you're watching, we're going to be doing Chapter 13, and this is going to be court proceedings. We're going to look at the trial itself and a little bit at the conviction, assuming there is a conviction after trial. And it doesn't go into acquittal, but I will mention a few things about acquittal when we get to those. Again, you do not have to watch these in sequential order if for some reason you're skipping ahead or this was a chapter that was confusing for you. Excuse me while I sip my coffee. You're perfectly able to watch what you want. Okay, so one of the things, as you look at, or as I teach this course, one of the things I tell my students is when I first started practicing law back in the 1980s, about a quarter of my misdemeanor cases went to trial. So there was a lot of plea bargaining, there was a lot of presumptive, but what's really happened in the last 30 or 40 years of the criminal justice system is the trials disappeared. So you have a table there on page 524 of your text, and this is, the name of the table is the felony convictions in state court. And you'll notice that 94% of cases are handled by guilty pleas, and that really means that trials are rapidly disappearing. The number is actually smaller today than that. It's down, depending where you look, it's down around 3%. So it's even half that. So trials are really disappearing. Now that doesn't mean that they're not important anymore. The trial is what's going to happen if you don't reach a plea bargain. So in many ways, what's going to happen determines what the plea bargain is. So trials retain some importance, but not as important arguably as the plea bargains. All right, so let's go to our first slide here, and let's talk about after the decision to charge. So adversarial proceedings, which is your trial, take place inside the courtroom. However, most of the important stuff happens outside the courtroom, and those are going to be those informal negotiations. So if you're looking at something like a drug possession case, or if you're looking at something like a larceny or a burglary, it's pretty rare that you're going to go to trial on those. So what you're going to negotiate is you're going to negotiate what someone is charged with. You're going to negotiate what the sentence is going to be, or where the sentence is going to be. Those are all things you can negotiate. Also the number of charges. There are some parts of the Constitution that apply to this out-of-court negotiation. The thing is, of course, there's a lot of stuff that applies to the trial constitutionally. Not as much to the negotiations. So let's look at the applicable constitutional amendments. First of all, we have Article 3, Section 2, the trial of all crimes, except in the case of impeachment, shall be by jury, and such trial shall be held in the state where the crime shall have been committed. That's your right to a jury trial. The Fifth Amendment, no person shall be compelled in any criminal case to be a witness against himself. That's your right against self-incrimination. And then we've got a number here in the Sixth Amendment. In all criminal prosecutions, you shall enjoy the right to speedy trial. That's one. Public trial. That means we can't have secret trials, even though we do have secret courts now. By an impartial jury, that describes the jury, so we've really got three there, of the state and district wherein the crime shall have been committed, and this really has to do with a concept called venue. To be confronted with the witnesses against them, that's your right against, or your right for your right of confrontation, is your right to subpoena, and to have assistance of counsel for your defense. That's your right to have your attorney. So you can see the Sixth Amendment has a lot of the trial rights. Um, the constitutional commands are important. Article 3, Fifth Amendment, Sixth Amendment are important because, trials are one of the few things in our society that can strip you of most of your rights. Um, you can lose your liberty, you can lose your property, you can lose any right you have to privacy, and in extreme cases, you can lose your life. We don't have a lot of executions anymore in the United States, but we still have a fair number. So that's the highest of the high standards. And you'll notice, since it's the highest, if you go back to that chart, um, I, I believe that if you look at all of the offenses listed on that chart, the guilty pleas range from a high of like 98 percent, or if we included misdemeanors, it'd be 99 plus. The one crime where there's still a very significant number of trials are murders, as a percentage of crimes committed. Now, there's not that many homicides in the United States. There's only about 14,000 in a given year. But, you know, assuming we catch 3 or 4,000 of those that are going to go to trial, it's, still something that we see a lot of trials for, really because there's less plea bargain negotiation going on. Okay, so let's talk about trials versus pleas. Only about 5% of convictions arise from trial. The other 95% are from guilty pleas. And pleas can be straight guilty pleas or they can be negotiations. Now, trials and guilty pleas promote different types of interests. First of all, guilty pleas are very efficient economically and bureaucratically for the system. On the other hand, trials are not. Trials take time. Trials really force us to, develop evidence. So they're less efficient, but they find us more facts. Well, what about, there's on that chart, I believe it'll have a chart. It says jury and probably says judge or bench trial. Let's talk about trial by jury. The Constitution says you've got a right to jury trial for all crimes except petty offenses, which are going to be really minor misdemeanors and tickets. Now, the court has used what's called the 6-month dividing line, where if you could face 6 months imprisonment, you have the right to a jury trial. Now, a lot of states don't like a lot of jury trials. They take more time, they're more costly, you have to have a venire, which is a jury pool. You got to do a lot. So states try to avoid these. But occasionally we will have jury trials. I've picked juries, and sometimes you're going to have a jury trial. So what are juries like? Well, of course, they are citizens in the United States, and you're going to have to call them. Now, use the term venire. That's the body of people that can serve on a jury. So you have a 12-member requirement, which is kind of an odd number if you think about it. I mean, it's not an easy number in which you have majorities on it. If it was 11, you could have a 6-5 majority. That should give you a hint that even though there's no constitutional right to a 12-member jury, we like unanimous juries, and we like juries that are 12. Now, states have tried to cut that number down. In 1972, we have the case of Ballou versus Georgia, where Georgia tried a 5-member jury and the court struck it down. So we don't mandate necessarily a 12-person jury. It is the standard across the United States. And grand juries, by the way, by its very nature, are usually larger. All right, I've been talking about jury selection going into this. Excuse me. And this is one of those constitutional rights you have in jury selection. Now, the jury pool is called the venire, V-E-N-I-R-E. Venire is just the pool of all the people that you can pick potential juries from. The Sixth Amendment of the Constitution guarantees you the right to an impartial jury, and it should represent a fair cross-section of the community. So the 14th Amendment, which works in conjunction with this jury selection, prohibits a systematic exclusion of people based upon race, gender, ethnic, or religious groups. Those are generally, those four there are protected classes. Now, I'm not going to go too far into that because a lot of that's civil law, and then we get into civil rights, but basically the federal government represents or recognizes that certain groups have special protection, like religious groups. You can't say, well, we're only going to put Catholics on the jury. We're only going to put Jews on the jury. You also can't say, well, I'm only going to put whites on the jury, or I'm only going to put men on the jury, or I'm only going to put people who were born in Mexico on the jury, ethnic groups. You can't do that. So we do have some legislation. We're not going to look too much at North Carolina's. We're looking first at federal, which is the Federal Jury Selection Act. And as I said, it requires a fair cross-section of the community. It really gives us a outline of what we expect. It kind of breathes life into that, your right to an impartial jury constitutionally. And as I said, no exclusion based upon race, color, religion, sex, which is gender, national origin, or economic status. Because, one of the questions is, who gets to sit on a jury? Do you want just people that are property holders? Do you want to have just people who have money? Also, age, I think, is one that could be in there very well, although it's not specifically addressed. So in most states, the juries have to be picked from this venire. So where does the venire come from? How does the state decide your name individually is or isn't on the jury list? Well, traditionally what they did was they just used property tax rolls. And what that meant prior to probably 1950 was you got white, male, older property owners. So you notice that you didn't hit the race barrier there, you didn't hit the color barrier there, you didn't hit the gender barrier there, you didn't hit the economic barrier there. You might hit national origin, you might hit religion. But remember, we had made it very difficult for certain groups to own property. So up until the 1960s, juries were almost exclusively all white, and they were white male property owners. You did have women on the jury, but it was somewhat rare. So in most states, we have this venire, and where do they get it? Now, states have different options. As I said, traditionally they used just property rolls. Now, North Carolina uses driver's license lists. That's one of the things we use here. But other states use telephone books, which I guess are kind of dying out, ironically. Census reports when they're available. Tax rolls, there's your property tax roll, it's still used. City directories, again, if they exist. And here's a big one, driver's license lists. Now, again, that's not it's not as big as you think. If your jurisdiction is just using driver's license lists, I was looking at some statistics. I was looking at a voting right case up in Minnesota, I believe. And I won't swear this is true, but I'm pretty sure I remember correctly. And it said that 30% of minorities living in the greater Minneapolis area never had a driver's license. So automatically you're skewing the population if you're just using your driver's license list. That's why courts like to say, well, use multiple lists. Now, certain people get exempted. Sometimes it's mandatory, yet you can't vote on a jury or be on a jury. Sometimes you can be exempt, and the state can grant you the exemption. So here are ones that are almost automatically exempted. You're never going to see them on a jury. If you're under the voting age, so if you're under 18, if you're a convicted felon, if you can't understand English or you're illiterate, you can't read. Now, also very often, certain occupations are exempted. Usually you have to go in and show it. So usually you have to show that there's going to be some good reason why you can't. Doctors, pharmacists, teachers, these are people that are all pretty important to society and have to be available readily, so we don't tend to force them to be on juries. Clergies often get exemption. Lawyers, although I've been called for jury duty. judges, some criminal justice professionals such as police officers, corrections officers, and some public employees. Those occupations are going to vary from state to state. It's pretty much up to the state to create that list. Now, even if you're in the venire, so even if you've got, let's say, 100 people that could sit on a jury, now we have to decide what 12 people are going to be selected for that jury. So this is jury selection. So the process is called voir dire, or voir dire. It's all bad Latin, don't worry about it. VOIRDIRE. So that's when you question it. Now, before we even get to the questioning, each side, the prosecution and the defense, has a number of preemptory challenges. They can look at someone on the jury and they can say, I don't want that person on the jury. He's going to rule against me. So that's keeping someone off of a jury without stating the reason you're keeping him off. And each side has a limited number of these charges, 6 in North Carolina, 10 in federal courts. Now again, I was just reading a case. It was a death penalty case, and whether it's true or not, it's generally thought that prosecutors do not want to put Jews on a death penalty case because they believe that Jews are among the groups that are most hesitant to impose a death penalty. Now, if you walked into a court and it was a murder trial and you said, I don't believe in the death penalty, I could never sentence anybody to death, you can be challenged for cause. You can be kept off the jury because you have this bias. A challenge for cause doesn't have to prove the bias exists, but you may have it. If I excluded Jews just because they were Jews, then that's a preemptory challenge, and it's also probably unconstitutional. If I challenge someone who said, I'm very wishy-washy about the death penalty, or I don't believe in the death penalty, that's a challenge for cause. In theory, you cannot remove someone preemptory or challenge for cause based upon race, gender, or minority. Is it done? Yeah, sadly it is done. Now, what are some common excuses that people raise themselves? Because, there's an old legal joke, don't trust your life or your property to 12 people too stupid to get out of jury duty. Because a lot of people, when they get that summons, and it's kind of unfair because it's a noble thing that you're doing there. You're performing a service for the community. A lot of people, when they first get that jury summons, I will get a phone call, how do I get out of jury duty? What do I say? So what are common excuses that we see for jury duties? Economic hardship. Look, if I get called for jury duty, I'm going to lose my job, or I can't do it. Advanced age. My mother is currently alive. She's 96. She would not sit on a jury. Illness. You can have someone that's in the hospital, need to care for small children, or just economic or practical distance to the courthouse. Now, is the fix in? Frequently, we do have a disproportionate number racially of black defendants being tried by white juries. Now, you might say, well, we have this rule, Mr. Chapman, that you can't discriminate. The problem is, it's not that we presume if I keep people off of a jury that we're keeping them off because of their race, religion, or gender. And you can see those two examples there. White juries trying black defendants, Jews off of capital cases. But really the burden is on the defense to prove there was discrimination. And believe it or not, in 2016, looking back 30 years, so all the way back to 1986 when I first started practicing, there has never been a proven single incident of discrimination against a minority. We have never recognized a preemptory strike, preemptory challenge as discrimination in 30 years in North Carolina. Now that, to me, is just crazy, because obviously somewhere in the 30 years that I practiced law, some prosecutor had some bias and struck off somebody. But we've never done it. That should show you how high the standard is. That has never been proved. So a lot of these rights, this right I'm talking about, you have it theoretically. It's practically very hard to enforce. The standard is called the Batson Standard, the federal standard. So this came out of a case, unsurprisingly, since it's called the Batson Standard, right? Of Batson versus Kentucky. And it said in this case that, and we needn't go exactly into the case, okay, that a preemptory challenge can be a violation of the 14th Amendment. And if you can prove a preemptory challenge was done on the basis of race, you get a new trial. So the Supreme Court really had a three-part test, and I think a hidden fourth part, because the most important thing here is that it's up to the defense to show that it was unfair. First of all, the defense shows it. You have to show that it's used for discriminatory reasons, that the prosecution did it because of race, religion, or gender. The sexual orientation, and this goes to U.S. versus Blaylock and Smith v. Klein, is not protected. So if I used a preemptory challenge in North Carolina to exclude someone who was gay, lesbian, transgender, doesn't meet that standard. Now, what about some actual statistics? I told you before that in North Carolina, in the 30-odd years, it had never been a proven case. Well, how often do blacks get excluded from juries? Well, over a 20-year period, it's not the same period, there were 7,241 preemptory strikes, in which 56% of the time blacks were kept off of juries because of preemptory challenges, and whites were only kept off 25% of the time. So it's twice as common. The traditional argument for most prosecutors is that blacks are too easy on defendants, so you keep them off. Just like Jews won't hold people liable for capital offenses, they won't execute them. Blacks will be too easy. Now, again, if you walk in the courtroom and say, it's a death penalty case, I don't believe in the death penalty, I can exclude you for cause. But if it's just, well, your name is Jewish sounding, or you are Jewish, and you say, yes, I'll listen to the evidence, I only have preemptory challenge to get rid of you. All right, so let's look at an actual case. This case is a 2008 case. It's an Alito case. Roberts, Stevens, Kennedy, Sotomayor, or Souter, Ginsburg, and Breyer all did it. It's a capital case. There were 36 potential jurors with 5 black potential jurors, all of which were dismissed on a preemptory challenge. So of the 36, they just purged them. And the court ruled that, yeah, this is going to be a violation of Batson. Now, the dissent, unsurprisingly, the dissent is from Scalia and Thomas, argued that, well, it's up to the courts. You should trust that the courts, controlled for this. You should trust the lower courts. And I'll just leave that there with no comment. Let's talk a little bit about voir dire or voir dire. There's how it's spelled. Now, as I said, you can pronounce it how you like. You can hear very funny pronunciations. I don't know if you've ever seen the movie My Cousin Vinny. You've got a Southern prosecutor who uses voir dire, I believe he says. It's pretty colorful. And I've heard people pronounce it all different types of ways. But it's just a Latin translation to speak the truth. And this is the process when you do it. So this whole preemptory or challenge for cause occurs when I'm asking questions of the defense. All right, let's move on. Let's talk a little bit about your public trial. And your public trial is really found in 3 different amendments, plus, and I included the North Carolina Constitution here. The 6th Amendment, your right to confront a witness, obviously that has to be done in public. Your 5th Amendment your general right of due process, and I guess you could slide in part of the 14th with due process as well. North Carolina has it specifically in Article 1, Section 24 of the North Carolina Constitution. Now, what we did here in North Carolina is that it's my squeaky chair if you're hearing that in the background, my apologies. What we did was we front loaded all our Bill of Rights. The Bill of Rights is not at the back of the North Carolina Constitution, it's at the front of the North Carolina Constitution. We don't pay as much attention to it as we pay to the federal Constitution, really for different reasons. I think there's more deference to the general legislature here than in other places. The right to a public trial, then, let's talk about this. At all stages, the defendant has the right to a public trial, and there are two distinct rights: public access and the right to attend your own trial. So public access is the right of the public to see what's going on. Now, that's not universal. There's a few instances where we can close it for different reasons. And then your right to be there when you have a trial. Again, at the actual trial determination of guilt or innocence, that's almost an absolute. So there's two distinct parts here: public access, defendant's rights. Public access, can John Doe off the street come in and watch the trial? Defendant rights, can Bill Smith, who's accused of murder, sit in his own trial? And I would say that the one in red there, the defendant's rights, has the stronger presumption. There are reasons why we can limit public access. So let's talk about some of those limitations. It's not an absolute right. Judges can say, we're not going to let you in. So what are some of the reasons they can do it? Well, think about courtrooms. Let's suppose you have a really, really high-profile crime. Let's talk a little bit about that. It'll be months and months and months, but let's talk about the trial coming up in Moscow, Idaho, on the killing of those college students. Well, trust me, the media is going to want to be there. But if it's going to be conducted in Moscow, Idaho, I've got to believe, and I've never tried a case in Moscow, Idaho, I've got to believe that you're going to have a relatively small courtroom. So if there's 40 seats in the courtroom, after the 40 seats, you're done. Usually in that case, what they will do is they will allow certain groups in, sometimes family members, and then you'll have a pool for the attorneys. Also, by the way, you are not in public trial guaranteeing that it gets broadcast on TV. The courts have struck down the mandatory that, yeah, you can't stop me from bringing a camera into the courtroom. That's why if you ever watch the news, you see a lot of artist drawings. So you'll have people coming in the courtroom and drawing pictures of the trial. So we can limit access if there is an undercover agent. So let's suppose an undercover agent is getting ready to testify in a trial. We can protect his identity. We can protect witnesses who need protection. We can protect children who need protection. All those can limit the public access. Now, the defendant's rights are not absolute either, but it's really based upon conduct. So if you're just sitting there, you pretty much are going to have a right. But if you're disruptive, if you're violent, if you're abusive, then yeah, they can throw you out of the trial. It's pretty rare. They don't like to do it because appellate courts tend to look with great suspicion at it. All right, let's look at the stages of the trial here. Okay, so I found these bubbles. I like these bubbles. You've got the opening statements. We'll go through that. We've got the presentation of the evidence. We've got the closing arguments. We've got the jury instructions, jury deliberations, and then finally we have the verdict. So taking these one at a time, let's look at opening statements. This is where you tell the jury, we're going to assume there's a jury. If not, we'll tell the judge. We're going to tell the jury or the judge what they're going to see and hear. And the prosecutor is going to lay out his case. Okay? He's going to say, let's suppose it's a burglary case. I'm going to prove that John Smith committed a burglary on January 1st, 2023 at 6 Main Street. And he's going to say what he's going to prove. Now, the defense has the option of saying, I'm going to prove my client is innocent, which if he's got a lot of evidence, he may go down that route. Or he's going to argue, I'm going to show you that the prosecution hasn't proved what they're saying. It may be true, it may not be true, but not beyond a reasonable doubt. Now, during opening statements, the prosecution can't refer to evidence that is inadmissible or incompetent or both. Because remember, I told you, you win or lose trials before they start. So inadmissible usually means that the defense has made a motion to keep out evidence before the trial starts. The judge has ruled, yeah, you can't use that statement, you can't use that gun, you can't use that blood evidence because it's irrelevant, incompetent, inadmissible, whatever we're talking about. You can't refer to it in the opening. If you do, it's a mistrial. So then we present evidence, and the prosecution goes first. They have to offer evidence to prove guilt beyond a reasonable doubt, and they have to offer evidence of each element of the offense. If you've got a crime that has a lot of elements, so let's take North Carolina's burglary statute. Okay, so there's a lot of elements. You have to prove there was a breaking, that you made a hole. If the door was open and you walked in, it's not technically a burglary. You entered. You have to put some part of your body in the house. If all you did was open the door, turn the handle, push the door slid open, but you didn't walk in, it's not an entry. It's still a crime, but it's not going to be burglary. All right, so you got breaking, entered, an occupied. If you're going to be a first-degree burglary charge, you got to show that someone's home. If the prosecution says, here's all the evidence that John Smith broke into Peter Parker's house, but you never showed in your presentation of evidence that anybody was home. When they're done presenting their evidence, the defense can stand up and say, Your Honor, I ask the charges be reduced from first-degree burglary to another charge because no evidence was presented of occupancy. So you break, you enter, an occupied dwelling. For first-degree burglary, it has to be a house. Again, there's other charges. You break into a store, there's other charges. At night, the prosecution is going to have to introduce some evidence what time of day the crime occurred. If it occurred at 10 a.m., not a first-degree burglary. So you broke, you entered an occupied dwelling at night, and then you have to show an intent to commit a felony therein. Usually robbery, but it could be I broke in with the intent to kill someone, I broke in intent to rape someone. That'd still be a burglary. So the rules of evidence restrict what the prosecution can present. And remember, we've framed this all out. We've written the play before it starts. The defense goes after it, and what we're trying to do, what I'm trying to do as the defense, is I'm trying to create a reasonable doubt. I don't have to show that the state is absolutely wrong. But what I have to show is, well, they may be right, they may be wrong, and since it's a maybe, you can't put a man in jail, or certainly can't execute someone, if there's a reasonable doubt. The big way you generate reasonable doubt, cross-examination. The Sixth Amendment allows you to confront people and examine them. If you do not let the defense in particular, almost exclusively, cross-examine witnesses, it's grounds for mistrial and reversal of it. It is fundamental to establishing the truth. Anybody can tell a good story. Anybody can tell a story that you saw a chupacabra or a Bigfoot or a ghost or a UFO. But let me ask some questions about it, like, were you drinking? Let's go to our burglary, and let's suppose that the state offers evidence that the neighbor across the street saw the burglary, and the neighbor across the street is testifying and gives, okay, it was 11 p.m., that makes it night, and I saw John Doe break into Peter Parker's house. Great. Breaking, entering, occupied dwelling was night. Now, cross-examination, I say, well, how far away are you? Well, my house is 2 miles. How are you going to see who somebody is as a mile, much less 2? Or let's suppose my house was across the street. Okay, were you drinking? Well, yeah, I was pretty drunk. Okay, so you can see that cross-examination really brings out the truth. One of the big issues that's often raised for the admission of evidence is hearsay. Hearsay, the simple definition of hearsay is this: an out-of-court statement being offered for for the proof of the matter asserted. Now, what that means, if we distill out the legalese, is that you are repeating something that was said or written, usually, claiming that what was said was true. So hearsay is not absolutely banned. And the prosecution often can get hearsay in. And some of the reasons they can get it in is, well, the witness who produced the hearsay isn't here, or it's not about what was said, but that someone else was there. So, long story short, and we won't go deeply into the hearsay rule, is there are 23 exceptions to the hearsay rule. Plus, there's a general exception, which really lets almost everything get in. If you can't get hearsay in, you're not trying very hard, is the general rule. Now, there are certainly cases when you can't get it in, but it's something that gets in a lot. So when you see on TV, objection, Your Honor, hearsay, you hear that all the time. Usually someone will say, yeah, but it's a present sense impression, or it's an excited utterance is another way you get in, or it's a regularly kept business record. All of those are reasons for hearsay to get in. We have compulsory process, and that's where you can force a witness to show up at trial. So let's suppose that I want to claim, as the defense, that the confession the prosecution seeks to admit was coerced. And for whatever reason, I couldn't keep the confession out. Well, one of the things I would do is I would call the cop, and I would say, I want you to tell me how the interrogation went. How many people were in the room? How long were you in the room? Did you let him have access to water? Did you let him go to the bathroom? Did you threaten him? Did you intimidate them? Is there a videotape? All these questions. Well, the cops may not want to answer that. So if I couldn't force the cop to be in the room, you know, if the only thing that's getting in the room is the confession itself, it's getting in the court, then it's hard to prove there was coercion. So it's mandatory that I can get a subpoena, I can get an order from the court that you have to show up. So I can compel witnesses to come to court to testify. So can the prosecution. All right, burden of proof. The prosecution carries the whole burden to prove the defendant is guilty beyond a reasonable doubt. Now, in doing so, they cannot call the defendant to take the stand. You can't force someone to testify. I've had clients who were innocent but were lousy people and were belligerent or mean-looking or abusive. And what you do not want in front of a jury is a person that is a bad person but innocent telling his story. Because even though we shouldn't, we tend to assume that good people don't commit crimes, bad people do. And bad people means often people that are unattractive, people that are violent, people that are abusive. And certainly they may commit those crimes at higher rates. But look at TV and movies. If you want to find a bad guy, very often look for someone who looks bad. So, what level of proof are we talking about here? Well, we're looking at proof beyond a reasonable doubt. And what's reasonable doubt? Doubt that would cause a prudent person, a reasonable person, to hesitate before acting in a matter that's important to them. It should be based on reason and common sense. And it should be substantial. And it should be, if you're going to convict someone, you should be able to persuade them that this person was guilty to a reasonable moral certainty. If you've got a real doubt whether someone committed the crime, you think he probably did, but I'm just not positive, then you should let him go. All right. Closing arguments. So you've presented all the evidence, and now we've got to decide, we're going to do a little summation. Prosecution goes first, defense gets the last word, often. No new evidence, prosecution can't express their personal beliefs, and the prosecution can't inflame the jury or prejudice the jury. And then we do jury instructions. So the judge tells the jury what their job is. Now, sometimes, believe it or not, it's not completely honest. Let's suppose you've got a crime that you don't think should be a crime. Let's suppose, a lot of people think locking other people up for possession of marijuana is crazy. So let's suppose someone's on trial for simple possession of marijuana. The prosecution establishes very, very clearly that yes, he did possess the marijuana. And you go back to and the judge will say, well, if the prosecution proves its case, you've got to convict them. But that's a lie. You have the right as the jury to disregard the law and find someone innocent. That's called jury lawlessness. However, and this is the interesting thing, a defense counsel can't tell you that. I can, at my closing, tell you you can simply ignore the law and find my guy innocent if you think the law is bad. The judge will simply tell you what the law is. He's not going to tell you that. You are presumed innocent until you're proven guilty. And this is the state has the burden of proof, proving that all elements of the crime were committed. Remember our burglary, the breaking, the entering, the occupied, the dwelling at night with intent to commit a felony therein. So then the jury goes back, and the jury has to reach a verdict. If it can't reach a verdict, we call that a hung jury. There's usually three things the jury comes back and talks about. Two, really, but the third is somewhat possible. Guilty, you committed the crime. Not guilty, you didn't commit the crime, or there's some special circumstances. And these usually relate to insanity. So we have, in most states, not guilty by reason of insanity, but in some states, believe it or not, we have guilty but insane. And then in bifurcated trials, split trials, the jury gets to decide, do you get life or do we execute you? If the jury convicts, that's the judgment. It's the final decision. It's got to be unanimous. Now, is it always? In capital cases, yes, but it's not absolutely required in other cases. There have been some states that have gone to an 11-1 or 12-2 on juries, because you don't want that holdout juror. If you've got a smaller jury, because remember, it absolutely doesn't have to be 12, the smaller it is, the more likely it has to be unanimous. Now, why do we want a unanimous verdict? Well, here are the arguments. One, it gives us more confidence. Well, if you've convinced 12 people as opposed to 9-3, or 9-3, or 8-4, or 7-5, or 6-6, it instills more confidence. It guarantees that you carefully looked at all the evidence. It ensures that we listen to the minority viewpoint, whether that minority viewpoint is just based upon thought or whether it's based upon group. It prevents government oppression. It helps prevent innocent people from being convicted. And it helps uphold the idea of proof beyond a reasonable doubt. Now, North Carolina, and this is one of the few North Carolina cases that's actually in your text, North Carolina has the Alford plea. And this arose, and we're going to look at that case in just a second, this arose in, unsurprisingly, the case of North Carolina versus Alford. It came down in 1970. It acknowledges that there's enough evidence to convict, but the defendant enters a guilty plea not admitting guilt, usually to a lesser charge. And you see this most of the time in North Carolina for juvenile cases where you're trying to not be found guilty as an adult. So let's talk about this. The Alford case, and as I said, it's a 1970s case, although the actual case started in 63. Alford gets arrested and charged with capital murder. So it's first-degree murder in North Carolina, capital offense. It's our only capital offense in North Carolina. and unsurprisingly, it's a court appointed. Okay. Um, there was a lot of evidence to show he did it. Um, there was some evidence to show that he was innocent, but not a lot. And Alfred recommended a guilty plea, but left the decision up to his client. So the prosecution said, I'll tell you what we'll do. We will accept a plea of second-degree murder. Now, in North Carolina at this time, okay, um, second-degree murder is still a very, very serious charge, okay, but at least you're not going to be executed. So, before the plea was accepted, um, the court heard two witnesses. They heard I believe it was a police officer, as I recall the case. It's been a while since I read it. There was no eyewitnesses to the crime, but the police testified, and there was a kind of quick presentation of the case. And then Alfred takes the stand and he says, I didn't do it, but I'm pleading guilty because I don't want to be executed. So there was an appeal, and the appeal said he only pled guilty because he faced execution, and this was fear or coercion. And it goes up, and this goes up to the Supreme Court, and this was a case written by White, who I've never read a lot of cases about, although he was joined in the majority opinion by at that time, some of the more conservatives on the court, Berger and Harlan, Stewart, Blackmun. Okay. The dissent said, and this is, we haven't, this is after two cases called Gregg v. Georgia and then the reimposition of the death penalty, Furman v. Georgia. The dissent said the death penalty is unconstitutional because it causes duress. If the state has that big cudgel, that big stick to hit you with, you're going to plead guilty because you're afraid you're going to be executed. So it's almost like, yeah, we're not beating the suspect to get a confession out of them, but we're threatening to kill him, and that makes him confess. And the majority opinion said, nope, sorry, we don't buy that. All right, I'm going to talk a little bit about jury nullification. Juries can nullify the law when they acquit a defendant, even though they believe that they're guilty beyond a reasonable doubt. This is seen as a safety valve to relax the law's rigidity and provide justice. And it can be a positive thing. And I mentioned some positive things where a group may not believe in marijuana convictions, but it also can be ugly. So, if you've seen the famous movie or read the book To Kill a Mockingbird, you saw an all-white jury there convict someone, a black man, of an assault when there was a very clear beyond a reasonable doubt. What you have to understand is, yes, jury nullification can exist where a jury ignores the facts and acquits, but there's an ugly side to it too. A jury can ignore the facts and convict. You don't get to inquire in and say, that was really stupid. How could you do that? Most convictions are convictions by guilty pleas. There's usually a straight guilty plea. In very minor cases, I will plead guilty. But probably 99% of the time, it's a negotiated guilty plea. Even if it's a speeding ticket. If I'm downtown representing someone for a speeding ticket, usually, we'll plead guilty, but we want it reduced from 15 over to just exceeding a safe speed so that we get fewer points on the license. The Supreme Court of the United States has decided that these are fine. Why do we get 95% of the time guilty pleas? Well, here are some of the reasons that we get it. One, the criminal process is very, very complex, and most people can't navigate it themselves. There's a lot more criminal law today than there's ever been. The crime rate is higher today, although lower historically than it was 20, 30 years ago. There's larger caseloads. There's political corruption in urban courts. By the way, there's political corruption in rural courts too. There's increased number of criminal justice professionals, and the prosecutors have more power. So it's difficult to win cases. As for the Constitution, um, when the defendant pleads guilty, they waive three important rights: the right to remain silent, so we can ask them about it; the right to your trial by jury, so we keep it out; and the right to confront people. Supreme Court of the United States has ruled that yes, you're giving up those rights, but these pleas must be voluntary and knowing. And the judge has to determine there's some factual basis for it. If the judge fails to ask questions regarding the plea, it is reversible error and we can have a trial. Okay, a couple more quick points and then I'll let you all go. The plea bargain debate. Which is better to figure out the truth? A negotiation or adversarial? Because if you say, well, obviously it's the two sides fighting each other, but remember, in an adversarial system, you're never going to hear from the defendant. In a negotiated one, they waive their self-incrimination and they've got to come up and tell the judge what they know. Of course, some people maintain that the guilty plea saves time. It certainly does. Others, that plea negotiations more than make up the time it takes to go to trial, because we go back and forth trying to decide, what the prosecution will or won't accept. Well, I have a fantasy for the next one, I'll be honest. My fantasy is, if you go down to district court in North Carolina, it used to be they printed out the actual who was going to appear. So in district court in North Carolina, here in Wake County, you have a morning session, and we'll say it runs from, say, 9 to 12, 3 or 4 hours, 8 to 12, 4 hours, we'll say. Then you have an afternoon session. And if you were to look at the calendar, it's entirely possible that there are, in that, let's just say it's a 4 hours, okay, that there's 200 cases scheduled. Okay, 200 cases, 4 hours, that's 50 cases an hour. That's less than a case a minute that you have to dispose of. Now, clearly, you can't do that. You're going to have to take plea bargains. And here's the fantasy, if every defense attorney one day stood up and said, set for trial, set for trial, set for trial, set for trial, the criminal justice system collapses of its own weight. Without plea bargaining, there's no way you can have this level of criminal law. Now, some people maintain that the guilty plea intimidates innocent people and emboldens the guilty. If you're innocent, you'll sometimes plead guilty just to get it over with or limit your damage. If you're guilty, you'll negotiate to reduce the charge. Others say that there's not a big difference between what would happen if you took the trial or you didn't take the trial. Final points. The public and the police are usually against plea bargaining. I'm not so sure they're right. I think, they say, oh, you want to get tough on crime. I think there's a lot more people convicted under plea bargaining than you think. Plea bargaining exists in the shadow of the trial. Now, this was one of the first things I really mentioned here. Prosecutors, judges, defense attorneys all act rationally. And they've got to understand that if we don't negotiate in this plea bargain and avoid the trial, then we got to bear the cost of that, the time, the money, the energy, the hours. If you didn't have it, well, that would be if you didn't have trials, if you only had plea bargains, that'd make things very different. There's bounded rationality and there's informational deficits where one of the things you don't know necessarily is everything the prosecution has. You should, or you don't know what evidence will affect the jurors. You should know it because there is open file discovery usually, but you don't always. So, I'm of two minds about this as a defense attorney. If I have a client who's guilty and is going to get convicted if he goes to trial, I like plea bargains. I'll be honest about it. If I have a client where there's a reasonable doubt, I don't like them because very often I got to say to them, well, you're still likely to be convicted and you're still going to face a lot of penalties. There's lots of possible ways to reform these, and it's certainly something that society is going to wrestle with. All right, on that note, I will stop it there. I hope you enjoyed this lecture. We've only got 2 more to go. This was chapter 13. We've only got 15 in the text. So whenever you're ready, you can log on and listen to chapter 14. Have a good afternoon or morning or evening. Fare thee well.